Welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by Livelaw. I'm your host, Ostika Das, and I'm here to take you through the most significant updates from this week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. But remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we cover the latest on Kavitha's bail, the Supreme Court's stern response to Telangana Chief Minister Revanth Reddy, a plea to ban Kangana Ranaut's upcoming film Emergency, and much more. So let's dive into the headlines. This week, in a significant decision, the Supreme Court granted bail to Kavitha, leader of the Bharat Rashtra Samiti, who had been arrested in connection with the Delhi liquor policy scam. The Enforcement Directorate took Kavitha into custody in March this year, followed by her arrest by the Central Bureau of Investigation while she was still in judicial custody. The Supreme Court bench, comprising Justices B.R. Gavai and K.V. Vishwanathan, questioned the impartiality of the investigation conducted by both the ED and the CBI, criticizing their selective approach in treating some accused as approvers. The court noted that the investigation in both cases was complete and that trials were unlikely to conclude soon given the extensive evidence and the large number of witnesses involved. The bench highlighted that under trial custody should not become a form of punishment and cited the special consideration for women under Section 45(1) of the Prevention of Money Laundering Act in matters of bail. The Supreme Court disagreed with the Delhi High Court's interpretation that the proviso to Section 45(1) of the Prevention of Money Laundering Act would not apply to women of high social or professional status. For more context, the Delhi High Court had ruled that Kavitha was not entitled to the benefit of the proviso, reasoning that she could not be equated with a vulnerable woman potentially exploited to commit an offence, which in the opinion of the single judge was the class of women for whom the proviso had been incorporated. The High Court cited the Supreme Court's December 2023 judgment in the Soumya Chaurasia case while arriving at this conclusion. However, the Supreme Court has categorically clarified while granting Kavitha bail that the Soumya Chaurasia ruling does not say that a woman should be denied the benefit of the proviso simply because she is highly educated, sophisticated, or holds a position as a member of parliament or member of legislative assembly. Accordingly, Kavitha's release was ordered upon furnishing sureties of Rs 10 lakhs in both the ED and CBI cases, along with conditions like depositing her passport and refraining from influencing witnesses. This week, the Supreme Court clarified an important legal point regarding the admissibility of statements made under custody in cases under the PMLA. The court ruled that if an accused person makes a statement while in custody for one PMLA case, that statement cannot be used as evidence in another PMLA case. The ruling came during a bail hearing where the court noted the lengthy incarceration of the petitioner and the delay in trial due to a large number of witnesses. The bench, comprising Justices B.R. Gavai and K.V. Vishwanathan, referred to the Supreme Court's 2022 decision in Vijay Madanlal Chaudhary v. Union of India, which allowed statements made to ED officers under Section 50 of the PMLA to be used as evidence. However, the court emphasized that the application of Section 25 of the Evidence Act, which protects against confessions made to the police under duress, must be assessed on a case-by-case basis in PMLA cases. The Supreme Court underscored that using such statements as evidence would be unjust if they were made involuntarily, particularly when the accused was under custody by the same agency. Very importantly, the court reiterated the principle that bail is the rule and jail is the exception, observing that even Section 45 of the PMLA, which is a special statute, does not alter this fundamental principle. In a significant development this week, the Supreme Court stayed a notification from the Ministry of Ayush that had omitted Rule 170 of the Drugs and Cosmetics Rules 1945. This rule required that advertisements for Ayurvedic, Siddha or Unani drugs could only be published with approval from licensing authorities. The controversy stems from an earlier directive issued by the Ministry of Ayush in August last year, which instructed state licensing authorities and Ayush drug controllers not to take action again under Rule 170, following a recommendation to remove the provision. The Supreme Court, which had previously expressed concern over this move during a hearing in April, was displeased to find that instead of retracting the directive, the ministry has now issued a notification on 1st July 2024, formally omitting Rule 170. The bench, comprising Justices Hema Kohli and Sandeep Mehta, noted that this action was contrary to the court's May order and stayed the effect of the notification until further directions. The Additional Solicitor General sought time to clarify the situation, but the court's stay indicates a serious reconsideration of the ministry's decision. This week, the Supreme Court expressed strong disapproval of comments made by Telangana Chief Minister Revant Reddy concerning the court's decision to grant bail to BRS leader Kavitha. These remarks came to light during a hearing on a plea to transfer the trial of the 2015 Cash for Votes case against Reddy. Initially, the court had indicated that it would not transfer the trial but would instead appoint an independent special public prosecutor. However, the discussion shifted when the court was made aware of Reddy's statements in which he allegedly insinuated that a political deal was behind Kavitha's bail. Justices B.R. Gavai, P.K. Mishra and K.V. Vishwanathan took serious note of these alleged remarks. Justice Gavai emphasized that the court's decisions are guided by conscience and judicial oath, not by political pressure or criticism. Justice Vishwanathan added that such statements from someone in Reddy's position are inappropriate and disrespectful judicial institutions. The bench highlighted the importance of maintaining respect for the judiciary, especially by those holding high office. In response to the rebuke, Revant Reddy later issued a tweet on X expressing his highest regard and full faith in the Indian judiciary. He clarified that certain press reports had misrepresented his statements, giving the false impression that he was questioning the judicial wisdom of the court. Reddy stated that he unconditionally regrets the remarks as reflected in the media and reiterated his firm belief in the judicial process and the independence of the judiciary. The Supreme Court this week directed that no coercive measures be taken against an ABP News journalist who interviewed notorious gangster Lawrence Bishnoi from within Punjab and Rajasthan jails. The interview, which was widely viewed and controversial, raised questions about how it was conducted within the prison and the implications it had. The Punjab and Haryana High Court had earlier initiated a suo motu case on the use of mobile phones in Punjab's prisons and had formed a special investigation team to probe the interview. The Supreme Court bench, led by Chief Justice D.Y. Chandrachud and including Justices J.B. Pardiwala and Manoj Mishra, was hearing a challenge against the High Court's order directing the SIT to file an FIR regarding the interview. Senior advocate Mukul Rohatgi, representing the petitioners, argued that the interview was a sting operation aimed at exposing criminal activity within the jail. The Chief Justice, while issuing a notice on the writ petition and granting protection from coercive action, remarked that while the journalist's intent was to expose criminal activity, conducting an interview within the premises of jail posed serious breaches of jail regulations. This week, the Karnataka High Court dismissed petitions filed by the Central Bureau of Investigation and BJP MLA BP Yatnal, which challenged the state government's decision to withdraw consent for a CBI probe into corruption allegations against Congress leader and Deputy Chief Minister D.K. Shivakumar. The case dates back to August 2017 when the Income Tax Department conducted raids on Shivakumar's properties, seizing around 8 crores. This led to a case under the Income Tax Act, followed by an Enforcement Directorate probe under the PMLA. Subsequently, the then Karnataka government allowed the CBI to investigate Shivakumar. However, after the Congress took over the state government in May 2023, it withdrew its consent for the CBI probe in November. The CBI and MLA Yatnal contended that once granted, such consent cannot be revoked, particularly with retrospective effect. The state, represented by senior advocate Kapil Sibal, questioned the maintainability of the petitions. A division bench of Justices K. Somashekhar and Umesh M. Adiga dismissed the petitions, affirming the state government's decision to withdraw the consent. In another significant development this week, a public interest litigation was filed before the Punjab and Haryana High Court seeking a ban on the upcoming film Emergency, starring actor and BJP MP Kangana Ranaut. The film, set to release on 6 September 2024, portrays former Prime Minister Indira Gandhi and delves into the political and social turmoil of the emergency period between 1975 and 1977. The petitioners, to baptize Sikhs claiming to be social workers, argue that the film promotes hatred towards the Sikh community and fosters enmity among Hindus and Sikhs. They allege that the film's trailer depicts inaccurate historical facts, misrepresenting the character of Sikhs and constructing an anti-Sikh narrative. The petition seeks the court's direction to the Union Government and the Central Board of Film Certification to review all records and documents related to the film certification. They have also requested the deletion of scenes allegedly targeting the Sikh community. The court is yet to decide on the matter, which has stirred significant controversy ahead of the film's release. This week, the Calcutta High Court dismissed a public interest litigation filed by advocate Sanjay Das, which sought to alter the roster of judges due to an alleged conflict of interest. Das requested the removal of Justice Amrita Sinha from cases involving police inaction, citing a potential bias as the West Bengal CID was investigating her husband. He argued that her involvement could undermine public confidence in the judiciary. However, a division bench comprising Chief Justice T.S. Sivagnanam and Justice Hiranmay Bhattacharya dismissed the petition, affirming that the Chief Justice has the exclusive authority to assign cases to judges, a role often referred to as the master of the roster. The court deemed the PIL an abuse of the legal process, possibly intended to intimidate the office of the Chief Justice. An exemplary cost of Rs 50,000 was therefore imposed on Das, who has been debarred from filing any further PILs. The court also dismissed another petition filed by Das, challenging a 12-hour strike by the BJP, citing this current order. In a notable decision this week, the Delhi High Court refused to quash the defamation case against Congress MP Shashi Tharoor concerning his controversial remark about Prime Minister Narendra Modi. In October 2018, Tharoor had stated that an unnamed RSS leader had allegedly compared PM Modi to a scorpion sitting on a shivling, calling it an extraordinarily striking metaphor. This statement led BJP leader Rajiv Babbar to file a defamation suit, arguing that Tharoor's remarks hurt the sentiments of millions of Shiv devotees worldwide. Justice Anup Kumar Mendiratta dismissed Tharoor's plea to quash the trial court's summoning order and the complaint itself, concluding that no grounds were sufficient to terminate the proceedings at this stage. The court ruled that it would be in the interest of justice to allow the trial to continue, thus vacating the interim stay on the defamation case. Tharoor now faces the continuation of legal proceedings in this matter. This week, in a matter concerning the legal protection of LGBTQIA+ individuals, the Delhi High Court directed the union government to treat as representation a petition filed against the exclusion of a provision equivalent to Section 377 of the now repealed IPC from the newly enforced BNS or Bharatiya Nyaya Sanhita. If you remember, Section 377, which previously criminalized consensual carnal intercourse, was partially struck down by the Supreme Court in the landmark Navteej Singh Johar case, decriminalizing consensual same-sex relations while retaining provisions against forced intercourse and bestiality. However, the BNS has completely omitted these provisions, sparking concerns that forced carnal intercourse against men and bestiality are no longer considered criminal offences. The petitioner's counsel had argued that the absence of Section 377 poses a significant threat to individuals, particularly within the LGBTQIA+ community, emphasizing the need to restore legal safeguards against non-consensual sexual acts, particularly to ensure the safety and dignity of queer people. Acting Chief Justice Manmohan and Justice Tushar Rao Gadela instructed the central government to address the representation swiftly, preferably within 6 months. The bench highlighted that the reintroduction of such a provision in the BNS would require a consensus among all stakeholders given the sensitive nature of the issue. The court also observed that the issue not only deals with the state but is also against the public at large. And that's a wrap for this week's Legal News Roundup. But before we bid adieu, the entire livelaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-visual format, we rely on your support. So here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below and hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for in-depth reports and analysis. Not only this, but the Livelaw channel offers memberships for only ₹89 per month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in comments and live chat, priority reply to comments, and for our Student Pass audience, early access to explainers and legal updates. I'm your host, Ostika Das, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to Livelaw. Thank you for watching.